In the state of New York, the responsibility of the landlord is to keep the premises in a reasonably safe condition. And reasonably gets back to that issue of they had to have either known about it or it had to have been there a long enough time. Or maybe it's a recurrent condition, whatever the defect is. For example, whenever it rains, there's a leak that comes from above onto the staircase. Even if they didn't know about those particular drops, they know that there's a leak there and that whenever it rains, it leaks onto that staircase. Well, they should have fixed that leak above so that it didn't leak onto the staircase. So that's what's called a recurrence condition. And there, the landlord, again, would be responsible because they didn't do what was reasonable under the circumstances, which is to repair that leak. What about the sidewalks? The general rule for sidewalks is that the owner of a building, let's deal with a multiple dwelling building with more than 3 units, because that's what the law is. It's separate. There's an exemption for homeowners of 1, 2, and 3 family homes. The owner of the building has the obligation to keep the sidewalk adjacent to the building in a reasonably safe condition. That means snow removal, that means debris, that means broken, cracked sidewalks. If you slip and fall, of course you should get medical treatment and you should call an attorney and consult about what your legal rights are.